Good morning to you all. I'm Mark Edmonds, Account Director at Engage in Learning. For those of you that are new to Engage in Learning, we're an e-learning company with over 25 years in the industry, and from our library of over 80 plus off-the-shelf e-learning courses, it's our legal compliance range that proves to be by far the most popular. And we pride ourselves in keeping on top of moving legislation, and we bring out regular updates to our training across the whole range. Now, the reason we're collected here today is that from the 25th of May 2018, the use of personal data at work will be regulated primarily by the EU's General Data Protection Regulation, the GDPR. Now, all companies are required to demonstrate compliance by design, where adequate systems, contractual provisions, documented processing, and staff training is in place. So obviously it's the staff training element that's starring today, and e-learning provides an efficient, cost-effective and consistent way of delivering your GDPR staff training, especially over a tight timescale to a remote and diverse audience. So in line with keeping on top of moving legislation, we have of course developed an e-learning course that covers the key definitions of GDPR, its core principles, individual legal rights, and quite importantly the consequences of non-compliance. We've already had very positive feedback from expert practitioners within our client base. Now, in order to run the webinar today and to communicate the ins and outs of the GDPR, as our course is delivering the knowledge that you and your staff need anyway to demonstrate compliance, I'm going to be using excerpts from the course as part of the content for the webinar. That spares you from listening to my dulcet tones for the best part of half an hour. So let's kick off with an introduction from the course, covering what the legislation is all about, what the regulation is all about.
Handled and gives legal rights to individuals concerning their personal information.
It's a European Union regulation intended to harmonise data protection across the EU.
It's overseen and enforced by national data protection authorities. In the UK, that's the Information Commissioner.
It covers all data, manual, electronic, audio and visual data, relating to an identifiable living individual.
And it covers any organisation, anywhere, that holds data about EU citizens.
So personal data has changed slightly for GDPR. The definition of personal data has been extended to explicitly include location data, online identifiers, and genetic data. And that's going to result in additional compliance obligations for some companies. For example, cookies. We all accept cookies. Cookies are treated as online identifiers. So let's see what the course says on the topic of personal data.
So what is the data in General Data Protection Regulation? You'll need to know it when you see it. Follow this individual during his day and identify what is personal data. You'll score 1 for correct identification, lose a mark for those you miss or those you identify incorrectly.
So this is an example of how we use e-learning to engage the learner. You can see here that I am making decisions on what I consider to be personal data. We'll leave a number of GCSEs and A-levels unchecked because as far as I'm concerned, that's not personal data, but we know that CCTV footage is. Car registration is also, you'll be interested to hear, but not which parking space you park in. And onto the new stuff, so the online data, and biometric data, the bank definitely. We mentioned cookies. So I think that's a fairly good stab. The icons you've got on the home screen of your laptop aren't treated as personal data. So let's see how we did.
Here's your score.
Personal data is data which can be used to identify a living individual, either on its own or in combination with other information.
Examples of personal data include a person's name, home address, email, and phone number.
But it can also extend to much broader categories of information. For instance, an employer may collect information on an employee relating to their performance, past experience, next of kin, and bank account details. This data is also likely to be considered personal data.
So hopefully getting the idea of how this webinar is working, you'll get some information from me and you'll get some information from the course. So I'm not just running the course pages so you can see what the course is. The idea is that you're benefiting from the content therein. I have got the closed captioning open. I thought that might help for some of you that may be struggling with the sound due to phone quality, etc. So that's obviously an optional panel, but it does help you keep up with the audio. Now, as far as just popping back to personal data, the elements that cover biometric and genetic data, they have specifically been added to the classification of sensitive personal data, which was previously covered by DPA. So those are, as well as being additional items of personal data, they've also been added to that sensitive classification, so that they can only be processed by an organization in those very specific circumstances. And the first section of the course continues with more key definitions and some scenarios. And we do like to use scenarios to engage the user. I'll show you how we do that a bit later on in the webinar. So GDPR has got 6 principles compared with the current 8 under the DPA. This is because the DPA principles concerning individuals' rights and the principle concerned with the overseas transfers of data, they're dealt with elsewhere in the regulation rather than being specific GDPR principles. So there's 6 principles remain from the DPA which are largely mappable, but they are more detailed in the GDPR. Plus, there's a significant addition of a new accountability requirement, which is some people are perceiving as a sort of a seventh principle. So let's take a look then at the principles.
The data protection principles in the GDPR set out the main responsibilities for organizations. At its heart are these principles.
We must process, collect, store, use, share, dispose of personal information fairly, lawfully, and transparently.
We must say why we are collecting it and use it only for that purpose.
We must collect what we need, no more, no less.
We must keep it accurate and up to date.
We must keep it for only as long as necessary and then destroy it safely.
We must keep it secure.
By law, we as data controllers and/or processors must follow these principles and demonstrate that we have to make sure that personal information is handled properly. Select each principle for more detail. Move on to explore key principles in turn.
So during the course, the learner can expand each of these, and each of these expansions does have comparison data between the DPA and the GDPR. So in this first principle, it's significant that transparency has been added, which is going to have an impact on how organizations design and implement their data processing activities. So I'll just open that one as an example because it has got a significant addition of the transparency. So let's dig a little bit deeper into the principles. First of all, we've got the fair, lawful and transparent principle, and we cover consent and conditions in this section.
You're probably fairly familiar with notices like these.
To comply with, and to demonstrate we comply with the GDPR, we must follow best practice guidelines when we ask for, record and manage consent.
If you have anything to do with dealing with consent, refer to this checklist.
So we've got a pop-up checklist that goes into more detail on consent, and then covering conditions.
Under the GDPR, personal information is considered to be processed lawfully if it's met certain conditions.
Here are some frequently asked questions about conditions and fair and lawful processing. Which one of these can be answered with a yes?
So let's do that then. Let's play with this screen. So can the HMRC obtain the details of an employee's pay without their consent? So yes, and I think comes under legitimate interest, I think. Can the police use personal data to fine an individual for speeding? Yes, they can. Does a utility company need to tell its customers why it collects personal data for billing when it's setting up a contract? So that's under the contractual necessity condition. And a boat broker collects personal financial information to comply with money laundering regulations. Can it share it with their sister yacht charter business to target its direct marketing? Well, we know that they can't.
You're quite right.
Although the first two options could be said to cause the individual harm, the processing is necessary for administering justice or for exercising statutory, governmental or other public functions.
The third option is necessary to carry out a contract the customer is entering into, and it's clear why the data is needed. If you want to review the conditions for processing, you can see them here.
So as you can see, this screen goes into quite a lot of detail for the conditions and the one before consent, and that's going to help your employees remain compliant. So moving on to the purpose limitation principle. Now, this is largely the same as DPA, and it covers being clear and transparent about the purposes for which you are collecting the data, and furthermore not changing these purposes without the individual's consent. So let's just remind ourselves of the basics of the principle.
Whenever an organisation processes personal data, it must do so only for certain specified explicit and lawful purposes.
And we must tell the individual what we are going to do with their personal data.
Specifically, we must state what personal data we are collecting, unless this is obvious. For example, asking a customer for their name, address and telephone number, or an employee for their bank details. How we will collect this personal data, such as through forms that they complete and emails that they send to us. How we will use personal data, for example, for future marketing, building a customer profile, or simply using their physical address to deliver a product. And who we may share the data with. For instance, their data may be held in a third-party IT supplier's cloud environment.
We have to tell people upfront before any data is collected and processed.
So there's a lot of really useful clarification on that screen, and I think you'll find that one useful for cascading this information down to your employees using the course. So on to data minimization. Now, with the data minimization principle, there's a shift from processing shall not be excessive to limited to what is necessary. So this is ensuring that the personal data held about an individual is just enough to do the job it's been collected for.
Before you can decide whether you're holding the minimum personal data, you must be clear about why you are collecting and using it.
Then you can ask yourself these questions. bearing in mind that the criteria should be applied to each individual.
Is this the minimum amount of data I need?
Do I have enough information? This is crucial when lack of context could result in misinterpretation.
Does it all apply directly to the purpose? Are there any irrelevant details?
Is any of this information just in case, or might be useful?
That's enough of data minimization. Move on now to the next principle.
He took the words right out of my mouth, as they say. The next principle is accuracy, and this is largely the same as DPA and requires personal data to be accurate and up to date. So let's just have a little look at how we cover this in the course.
Keeping personal data accurate and up to date makes business sense. The consequences of not doing so can range from inconvenience to serious financial, emotional, and reputational damage.
Consider the personal data you are responsible for. Ask yourself, will the data change? How often? How can you keep it up to date efficiently and reliably?
For example, you could periodically ask data subjects to check the accuracy of the information you hold. Ask your line manager what systems you need to follow.
Move on now to the next principle.
So the next principle is data retention.
The data retention principle, that personal data should only be kept as long as necessary, reduces the risk that it will become inaccurate, out of date, or irrelevant, or accidentally disclosed.
So, when deciding what data to collect, think about when and how it can be destroyed. Ask your line manager about whether or not the data that you hold in your possession should be retained or disposed of.
The main difference in GDPR with data retention is that there are more exceptions. So, for example, archiving purposes in the public interest and scientific purposes. So there's more listed, specified exceptions for data retention guidelines. Moving on to data security. Now, we've got a whole separate course on information security. However, for the purposes of our GDPR course, we cover some essential do's and don'ts to ensure compliance with GDPR. No major differences here between DPA and GDPR. And in this section of our e-learning course, we use scenarios to cover key learning points. So let's have a look at this first scenario.
Here's a scenario you may be familiar with. What do you think about it? Should Emily have started work on the train? Should Emily have been working like this?
So I'm going to read the scenario to you. Emily is traveling back on a train from a long day of meetings. She's working on her laptop with personal data on a USB stick. She falls asleep and wakes up as they are pulling into the station. In the rush to get her things together, the USB stick falls on the floor and she gets off with it. She gets off without it. When Emily discovers the loss, she realizes it was unencrypted data. Now, I'm sure this isn't an unusual scenario. I'm sure some of us have fallen asleep on the train with or without a laptop. So should she have worked with personal data on an unencrypted USB stick? Well, I think we all know the answer to that. Let's get some feedback from the course.
You're right. Emily was handling personal data, which she has to keep secure under the GDPR.
So, and the other three screens in this course continue to use scenarios to deliver the data security principle. Now, the most significant change, and the one I'm sure that you've all heard about, is the introduction to GDPR of the concept of accountability. So this requires that data controllers are responsible for and are able to demonstrate compliance with the data protection principles. And we touched on right at the beginning, where companies are required to demonstrate compliance by design, where adequate systems, contractual provisions, documented processing, and staff training are in place. So what we cover here is accountability, and also we introduced data breaches as well. So let's have a look at how the course communicates this to your staff.
The GDPR promotes accountability and governance alongside its transparency requirements to protect personal data and minimize the risk of data breaches.
It means we design privacy into our systems and may be required to conduct privacy impact assessments when things change.
And we must also be able to demonstrate that we comply with the GDPR, which means that you must follow our data protection and information security policies, and maintain data protection documentation precisely.
And a bit on data breaches.
A personal data breach happens when there's a breakdown of security leading to the destruction, loss, alteration, unauthorized disclosure of, or access to personal data.
We have to report a breach where it's likely to cause someone significant damage. For example, if it could lead to discrimination, financial loss, identity theft, or reputational damage.
If we do have to report a breach, we have to do so within 72 hours.
So having covered the data protection principles and the concept of accountability, the course moves on to deal with the rights of data subjects, which is, again, a key part of the GDPR regulation.
The GDPR sets out the rights people have over their personal data.
We have the right to know why personal data is collected and what will be done with it.
We have the right to see what information is held about us.
We have the right to have data corrected and erased.
We can restrict how our data is processed.
We can insist it's transferred from one data controller to another.
We have the right to object to decisions made on the basis of our data.
And we have rights relating to profiling and decision-making that does not involve a human.
You can find out more by selecting each option.
And you can, of course, do that and dig down into each of these items. Now, in order to get you and your staff thinking about data subject rights, we've introduced a couple of examples, a couple of scenarios, which will help you think. The recruitment one's quite interesting. Basically, it says anything you write down, the data subject has got a right to view it. So don't write anything down that you wouldn't want to be heard in an employment tribunal. I'm going to play the direct marketing piece because that is also thought-provoking.
Unwanted direct marketing is a hot topic. The GDPR says that individuals have the right to prevent their personal data being used for direct marketing.
That means people can tell organizations to stop using their personal data.
Or not allow it in the first place.
Which means that, for example, direct emails must include an unsubscribe option.
Direct marketing is not confined to selling. It also includes promoting particular views, even if they're good causes.
And it's not confined to print or phone. It includes text and email.
If you do direct marketing, use the Information Commissioner's checklist to help you comply.
And of course, your learners can expand that checklist and save it as a PDF should they choose to. So now we move on to the crunch, really, of why all this matters. So if any of your staff are saying, well, so what? The last section, why compliance matters, really sort of drives home the crunch of it all. And the what if, really.
All of these are examples of where the Information Commissioner's Office has prosecuted and or fined
an individual or an organization for data protection breaches.
Data protection breaches are serious. We have to report them in detail to the ICO within 72 hours, and they can attract maximum fines of 20 million euros, or 4% of worldwide turnover, whichever is the greater.
So obviously GDPR certainly does matter with that increase in maximum fines of up to 20 million or 4% of worldwide turnover. There's been a lot of talk about that over the last last 18 months. And we continue to use this section to communicate the importance of compliance and to ensure that everybody...
Here's a list of general
everybody's doing their bit.
golden rules to help you stay compliant with the GDPR. As you look at them, please consider how they relate to your day-to-day work.
And then we've got a little question here.
There are consequences if we fail to comply with the GDPR. Do you know what the penalties are for you should you fail to comply with the regulation?
And then finally, one about the consequences to the organisation.
An organisation that's found to be in breach of its data protection obligations can be investigated and suffer reputational damage, compensation claims and fines.
The fines can be extremely punitive and can seriously impact the financial health of an organisation, which makes data protection compliance a high priority.
And then finally, there's just a wrap-up screen, which brings it all together. So hopefully, the way I am delivering this webinar with my bits and the bits from the course, that's bringing you up to speed with the regulation, and it's got you starting to think about how you can disperse and cascade necessary knowledge throughout the organisation. Now you can see from the menu here that as well as the 5 sections, I've also got a post-test, and this is a critical part of the e-learning because it validates the knowledge and reports the score back to your learning management system. The way we deal with the post-test is that we have a set of questions for each of the sections, and each learner gets 3 attempts at each section test, and each of those 3 attempts has got a different set of questions. So we use a question bank and we randomize question selection from there. The pass mark is set as a default to 80, and they will get a certificate will become available once they've achieved 80% or more. And part of the tailoring that we can do for you is that we can change the pass mark. And so moving on to tailoring, obviously with a subject like GDPR and other legal compliance, you might have your own links to your own policies, your own guidelines, your own IT security policy, as was referred to in the data security section. A couple of approaches. One is you can add that content at LMS level, so it sits next to our module. But one of the features that we've brought in, and I'm just going to switch screens here quite slickly, hopefully. There we go. So one of the features we've brought in is the ability for you to be able to add your own content to our e-learning courses. So you can see here that I've got an Add Content button, and that brings up a toolkit that I can use to either copy and paste or type text or HTML code in. I can choose to embed media and direct to point to a video or a web-based document. So if I just type in demo here, I can also set the name of the button. I can choose an icon, and I can say whether it's mandatory or not. And that will sit in the navigation bar here. If I made it mandatory, it would hide the next button, and I wouldn't be able to navigate through the course without seeing that company-specific data. So I'm just going to now switch back to where I was. Oh, and also on the authoring tool, it also allows you to change the logo. You can switch from Engage in Learning to your own company logo as well. So the editing course editor allows you to do that, as well as add your own content. So back to the menu, a couple of other features I want to show you. One that covers translation. So all of our courses ship with a language translator. This translates in real time to over 120 languages. So you can say I can pick Corsican, and that will change to Corsican in real time. It uses a disclaimer to explain that it uses Google Translate, but the feedback that we're getting is that it really does help deliver the key elements of the course in a more familiar written language. The audio narration does remain in English. So other things about our e-learning, they're all in the SCORM format. We provide hosting, and we can provide a full learning management system, or we'll provide a SCORM package if you've got your own learning management system. We've got very flexible licensing options. You can license just the GDPR course, or you can include it in a bundle of, for example, 5, 10, 20 of our courses from our 80 plus to choose from. Pens at the ready, just to give you an idea of pricing. Just got a couple of examples. If there's 200 staff that you wanted to deliver our GDPR e-learning course to, then that would cost you £2,500. If there was 1,000 people in your organisation, that would cost you £5,500. So that gives you just a couple of price points there. Obviously, we can provide you with a tailored quote to match the exact number of employees you've got and the bundle of courses that we provide. So yes, that's the delivery on the GDPR and a little bit about us and how the courses work. I hope that has generated some interest. Right, so thank you very much. I hope that was a useful 36 minutes of your Thursday.